Welcome to the Deep Dive. Today, we're diving deep into the thought of Joseph Raz, a really pivotal figure in legal philosophy.
Absolutely, a major thinker.
And this deep dive is specifically for you, the learner. It's brought to you by Sinorbit Academy, Sri Lanka, and we're aiming to make his, well, often complex ideas on authority and law really clear for your studies.
Yes, and we should state up front, this material is made available to students by the University of London.
Right, and it's intended purely for educational purposes. So, with that said, good luck to all of you for your exams.
Definitely. Now, Reza is often seen as building on HLA Hart's work, wouldn't you say?
Yes, Hart's intellectual heir in many ways. But he didn't just, tweak things. He offered a pretty revolutionary perspective on authority itself.
He really did.
Yeah.
And understanding that perspective is crucial for grasping how law and morality relate, or perhaps don't relate, in his view.
And it helps make sense of that whole positivist take on law, especially judicial discretion, what judges do in those really tough cases.
Exactly. And it's worth noting, though maybe for further reading, his later work, like the 2019 article on the rule of law,
Oh, yeah.
he really emphasizes its role in preventing arbitrary government, linking it back to the basic jobs of government protecting us, helping us coordinate.
Shows the consistency of his thinking, I suppose. So our mission today is to unpack Raz's key concepts. We've got the paradox of authority, the service conception,
Right.
the normal justification thesis, and exclusionary reasons.
The big ones.
Yeah, and see how they all fit together, how they shape his view of law, its authority, its limits, and how that impacts the debates with, say, soft positivists and Dworkin.
And crucially for you listeners, we'll focus on the structure of his arguments.
Yeah.
That's really key for studying this effectively for exams.
Okay, let's jump in. The paradox of authority. It sounds simple, but it's quite profound.
It really is.
Yeah.
The basic question is, why should we ever follow an authority?
Right, because if they tell you to do what's right,
Well, you should do that anyway, right? Because of the underlying reasons. The authority seems, well, redundant.
pointless, yeah.
But if they tell you to do something wrong,
Then obviously you shouldn't do it.
exactly. So the authority seems either useless or harmful. That's the paradox. It seems irrational to follow authority.
Okay, so that really puts the whole idea of legitimate authority on the back foot. But Raz offers a way out, doesn't he?
He does, with his service conception of authority.
Ah, yes, the service conception. The doctor analogy is helpful here, I think.
It is. Think about it. You go to a doctor. Why? Because they have expertise, knowledge about health that you likely lack. So, following their advice, take this medicine, change your diet. It's rational because it serves your interest in getting well.
Right. Ignoring the doctor would be like ignoring a medical textbook that actually applies to you. That doesn't make sense.
Precisely. The authority, the doctor, is providing a service by mediating that complex knowledge for you.
So how does Raz apply this idea to practical authorities, like the law?
In a similar way. If the law helps solve problems, coordination problems, knowledge problems that you can't easily or efficiently solve on your own,
Okay.
then following the law can be perfectly rational. Even if the law isn't always perfect, isn't always 100% right.
As long as it's more likely to lead you to the right outcome than if you just tried to figure it all out yourself.
That's the core of it. As long as following the directive makes you better off in terms of complying with the underlying reasons than you would be otherwise, it serves your interests by guiding you better. That's a service conception.
Okay. Now, normally when we make decisions, we weigh things up, right? The balance of reasons, as philosophers call it.
Everyday practical reasoning.
Like, I'm hungry, there's a nice restaurant nearby, but maybe it costs a bit much, and maybe I should eat something healthier anyway. I juggle those reasons.
Exactly. You weigh the pros and cons, the different considerations.
And this leads us to Raz's normal justification thesis. Can you unpack that?
Sure. The normal justification thesis, or NJT, basically says this. An authority is justified if and only if you are more likely to act correctly on the balance of reasons that apply to you.
Okay.
By following the authority's directives, than by trying to figure out and act on that balance of reasons yourself.
So it links back directly to the service conception.
Absolutely. It is the core of the service conception. The justification for the authority is that it helps you comply better with the reasons that already apply to you.
Like the doctor again. They mediate the complex medical reasons.
Right. And give you a directive prescription that helps you act in line with those reasons. Hopefully better than you could on your own.
So applying this to law, is the law's authority based purely on expertise? Like, does the legislature know better than us in all things?
Well, that's a good question. Expertise is one possible basis, but Raz acknowledges it's not the only one. Sometimes it's about solving coordination problems.
Like driving on the left or right side of the road?
Exactly. The specific rule doesn't matter as much as the fact that everyone follows the same rule. The law provides that necessary convention.
But what about more complex areas? Like criminal law, criminalizing rape or theft. That seems rooted in morality, not just coordination.
It is rooted in morality, fundamentally. But the law does more than just say don't do morally wrong things. It provides specific technical definitions. Think mens rea.
The guilty mind.
And actus reus.
The guilty act.
Right. These legal concepts, you could argue, function like conventions to ensure fair and consistent application, and the state's authority to punish. Maybe that stems from preventing, vigilante justice or excessive private retribution. It provides a structured response.
Okay. And taxation, that seems like a coordination issue too.
A classic example. How do we fund public services? Everyone just chipping in what they feel like. Probably not efficient. Taxation provides an authoritative mechanism to solve that coordination problem.
Raz actually lays out several bases for legitimate authority, doesn't he?
He does. He identifies 5 main ones. First, wisdom or expertise, like the doctor example.
Okay.
Second, having a steadier will or being less subject to bias than individuals might be in the heat of the moment.
Right, like a referee in a game.
Good analogy.
Mm.
Third, the ability to use indirect strategies like using tax revenue for poverty relief, which is an indirect way of achieving a moral goal.
Makes sense.
Fourth, reducing the costs, inefficiency, or anxiety of decision-making. Standardized medical treatments might fall here.
Mm-hmm.
And fifth, crucially, solving those coordination problems, like the rules of the road.
So the bottom line for Raz is that it's rational to follow an authority if it's better placed to get things right for whatever reason: expertise, coordination, efficiency.
Precisely. If it helps you better conform to the reasons that apply to you.
But, and this seems important for students to remember, Raz isn't saying the law always has justified authority over everyone in every situation.
Absolutely not. That's a crucial nuance. Take a road safety engineer. Does the law telling them to wear a seatbelt have authority for them in the Razian sense? Probably not. They already understand and act on the underlying reasons perfectly well.
Right. The law doesn't serve them in that specific instance.
And areas like personal morality. Well, whether the law has legitimate authority, there is a whole separate, very complex debate.
Yeah.
Raz's theory provides the framework, but the application isn't automatic.
Okay, so we follow authority when it serves us better and acting on reasons. But what's actually going on in our heads when we do that? How does it change our reasoning? This brings us to exclusionary reasons.
Yes, exclusionary reasons.
Right.
This is a really interesting part of Raz's theory about practical reasoning itself.
So what are they?
Well, when we decide to follow an authority's directive, Raz says we often treat that directive not just as another reason to consider, but as a reason to exclude, acting directly on our own assessment of the original reasons. We sort of set aside our own weighing process.
You stop juggling the pros and cons yourself.
In a way, yes. You take the directive as the primary guide for action in that specific context. It excludes the original reasons from your immediate deliberation.
Raz makes a distinction here between deliberative and executive phases of reasoning. Can you explain that?
Sure. Think of it like this. The deliberative phase is when you're weighing all the options, considering the reasons for and against, and trying to decide what to do.
Right. The thinking part.
Exactly. The executive phase is when you've made the decision and now you're just carrying it out, acting on it.
Okay. How does that relate to authority and exclusionary reasons?
Well, think about a student law society, maybe deciding on subsidies for the summer ball. There's a debate. People argue about fairness, budget constraints, whatever. That's deliberation.
Mm-hmm.
Eventually they vote. A decision is made, let's say, £10 subsidy per ticket. That decision marks the end of the deliberation on that issue for the society.
Got it.
Now, the treasurer, or whoever, moves into the executive phase. Their job is to implement the £10 subsidy. They don't, or shouldn't, go back and reweigh all the arguments about whether £10 was actually the best amount.
Because the society already decided that.
Exactly. The society's decision acts as an exclusionary reason for the treasurer. It excludes the original reasons, budget worries, fairness arguments, from their immediate task, which is just executing the decision.
Okay, that makes sense. So, in law, a judge's ruling.
That ends the deliberation for the parties, ideally. They move to the executive phase of complying or appealing, which starts a new deliberation at a higher level.
And Parliament passing a law.
That law becomes an exclusionary reason for citizens and officials. You follow the law, you don't constantly redebate the policy reasons behind it every time you act. This allows for coordination and stability.
It sounds a bit like making a promise.
That's another great example Raz uses. When you make a promise, you've deliberated beforehand. The promise itself then acts as an exclusionary reason guiding your future action. It excludes simply reevaluating whether keeping the promise is convenient later.
Right, that's what gives promises their binding force, allows for trust.
Exactly, and Raz calls the force of these exclusionary reasons peremptory. They replace or preempt the underlying reasons. You don't add the promise and the original reasons for making it together. That would be double counting. The promise takes precedence.
But are these exclusionary reasons totally absolute? Can they never be challenged?
No, not entirely absolute. Their scope is usually limited to the reasons considered during the original deliberation. So if significant new evidence emerges, that wasn't considered.
Like in a court case, finding new DNA evidence?
Precisely. That might override the exclusionary force of the original judgment. Or, if the deliberative process itself was deeply flawed, say, a judge was bribed or applied a law that was already repealed.
Okay, procedural fairness issues.
Right. That could undermine the directive's exclusionary force. It's not a blank check.
So Raz gives us this framework for understanding why following authority can be rational through the service conception and exclusionary reasons. How does this connect directly to his view of law?
Well, the crucial step is that Raz argues law, by its very nature, claims authority.
It presents itself as something we ought to follow.
Yes. It demands compliance. Think about legislation, court orders, even everyday legal rules. They don't usually present themselves as mere suggestions or advice. They claim the right to direct our conduct.
Regardless of whether we personally think that specific law is wise or just.
Exactly. The law claims obedience simply because it is the law.
And for Raz, this claim to authority actually sets limits on what can count as law.
Precisely. Because if law is authoritative, it must be able to function as an authority. It needs to provide authoritative directions.
And this is where his famous argument comes in, that the content of the law, what the law is, cannot depend on moral arguments.
Correct. This is a cornerstone of his hard positivism. Let's walk through the logic, because it's important for exams.
Okay, step by step.
Step 1. Authority, as we've said, has to mediate between reasons and the people subject to it.
Right. The service conception.
Step 2. It does this mediating by deliberating on the reasons and then issuing directives.
Okay, like the doctor issuing a prescription.
Step 3. Crucially, those directives have to actually tell people what to do. They need to be specific enough to guide action. Just saying, do the right thing in a complex moral dilemma isn't really an authoritative directive. It throws the deliberation back onto the individual.
It doesn't guide you to the executive phase.
Exactly. It keeps you stuck in deliberation. Step 4. Therefore, Raz argues, a law that says something like act according to morality or do what is just cannot be truly authoritative as law. Why? Because morality itself is often controversial and subject to disagreement.
So, to figure out what the law requires, I have to engage in my own moral reasoning.
Precisely. You'd be back in the deliberative phase trying to figure out what morality requires, rather than being guided by a clear legal directive. The law wouldn't be performing its mediating, guiding function.
But laws often do use moral language, like fairly and reasonably or the right to life. How does Raz account for that?
Step 5. Raz argues that when laws use such broad moral terms, they aren't typically imposing direct, fully formed duties based on those terms alone. Instead, they are primarily conferring power or discretion on officials, usually judges.
Power to do what?
Power to make specific orders or interpretations based on their understanding of those moral concepts within the legal context. A judge deciding what constitutes reasonable care, in a negligence case, for instance.
And then that specific judicial decision becomes a more concrete part of the law.
Yes. The higher court rulings create more specific directives. Step 6. The fundamental idea is that an authority can't authoritatively direct unspecified behavior. It's not just that morality is controversial. The law can't hinge on anything that requires the subject to undertake extensive, uncertain deliberation just to know what's commanded. Such laws fail to guide subjects effectively to the executive phase. Their main function, Raz insists, is empowering judges.
So, for law to be law in Raz's sense, it needs to be identifiable based on social facts, what the legislature enacted, what courts decided, without needing a separate moral evaluation to determine its content.
That's the hard positivist core. It has to be ascertainable before you get to the moral argument.
And this puts him at odds with, well, both soft positivists and Ronald Dworkin.
Definitely. Let's quickly sketch those positions. Soft positivists, sometimes called inclusive positivists or incorporationists.
Like Hart, maybe, in his later responses?
Arguably, yes. They say law can, though it doesn't have to, incorporate moral criteria for validity. So a constitution might say, any law violating fundamental moral rights is invalid. For them, that moral standard becomes part of the law itself.
Whereas Raz would say that just gives judges power to strike down laws based on their moral view.
Essentially, yes. He'd say it refers to morality, granting discretion, rather than incorporating morality as law.
And Dworkin.
Dworkin goes much further. For him, law is ultimately determined by the principles of political morality that provide the best justification for the legal practices of a community. Figuring out what the law is inherently involves moral reasoning. Apparent rules might even be overridden by deeper moral principles.
So completely different from Raz.
Polar opposites on this point. Raz challenges both because, for him, law needs to be specified before you get to court. If law depends on controversial morality, it's not specified.
Individuals wouldn't know clearly what's required, and they'd face uncertain judgments from courts who are essentially engaging in moral philosophy.
That's Raz's concern. Such laws are really, in his view, conferring power on judges to make decisions based on morality, not applying pre-existing morally infused law.
Okay, but I can see a counter-argument. Laws do say things like, act reasonably. Isn't it a bit counterintuitive to say that's not a legal standard, but just a grant of power? Doesn't that challenge Raz's own theory of authority? Isn't the law trying to guide us using that standard?
That's a very strong point, and it's exactly the kind of critique Dworkin later made against Raz.
Oh, okay. What did Dworkin argue?
Dworkin argued Raz was simply wrong to say that authoritative directives can include moral standards and still guide behavior. He thought people would reflect on what reasonable or just means in context, and that reflection would guide their actions. They'd try to comply with the moral standard embedded in the law.
And Raz's reply to that?
Raz would likely say, sure, people might reflect on morality and it might change their behavior. But the key point for legal authority is whether they can reliably comply with the correct legal standard. Meaning, the standard as it would be authoritatively determined by the legal system, ultimately by the courts. Just reflecting on morality doesn't guarantee you'll arrive at the legally correct understanding. The law, Raz insists, requires compliance with the correct standard, not just a personally reasoned approximation. So, treating these broad moral clauses as direct authoritative commands is, for Raz, still a mistake about how legal authority properly functions.
So the gap remains. For Raz, the practical difference in behavior driven by personal moral reflection isn't the same as complying with a specific legal directive.
Exactly. And his fundamental disagreement, especially with Dworkin, comes down to this. Raz finds it, well, almost absurd that the law could be something no one has ever actually thought of before lawmakers, judges, anyone, simply because it turns out to be the true requirement of morality.
Because morality's requirements might be incredibly complex or undiscovered.
Precisely. That makes law potentially as open-ended and uncertain as ultimate moral truth itself, which seems completely at odds with the idea of law providing predictable guidance.
Whereas Raz sees legal systems as empowering judges to work within existing materials, apply rules, interpret, modify, even create new law, but always constrained by legal sources and procedures, not just discovering free-floating moral truth.
That's a good summary of his position. Law develops through authoritative acts, not just through moral discovery.
Okay, quite a journey through Raz's thought there. Let's try to synthesize the main takeaways for everyone listening, especially with exams in mind.
Right. So first, the paradox of authority, why follow anyone? Raz's answer. The service conception. Authority is legitimate if it helps you better comply with the reasons that already apply to you.
And that's formalized in the normal justification thesis. Follow the authority if you're more likely to get it right that way.
Then we have exclusionary reasons. These explain how authority works in our reasoning directives, replace or exclude our own deliberation on the underlying factors, moving us from deliberation to execution. And all this builds to his view of law. Law claims authority. To be genuinely authoritative in Raz's sense, it must provide identifiable guidance based on social facts, not depend directly on controversial moral evaluations for its content.
Which leads to his view that legal references to morality often confer discretion on judges, rather than incorporating morality directly into the law's content.
Exactly. And understanding that whole chain of reasoning, paradox, service, NJT, exclusion, limits of law, is crucial. See how each piece connects to the next.
Definitely focus on that logical flow for your studies. And be clear on the distinctions, Raz's hard positivism versus soft positivism, and his deep disagreement with Dworkin over the role of morality in determining what the law is.
Remember Raz's core idea. Law needs to provide clear, predetermined guidance to function as a legitimate authority.
And if you want to explore further, definitely check out the further reading list from the University of London. There's always more depth to find with Raz. So, let's end with a final thought for you to chew on. Raz powerfully argued that a key purpose of the rule of law is preventing arbitrary government. Think about this. Given his insistence on excluding direct dependence on morality from the definition of law itself, does that exclusion ultimately strengthen the rule of law's ability to prevent arbitrary power, perhaps by ensuring clarity and predictability? Or does it potentially weaken it by separating law from the very moral standards that might best guard against injustice?
That's a deep question. Does clarity trump substantive justice in defining law's role against arbitrary rule?
Something to ponder as you continue your studies. Thanks for joining us on the Deep Dive.